Lord. I'd taken the court just before the lunch and adjournment to Zustovic and Croatia, and to paragraph 106. I neglected to show you whilst there, paragraph 100. Could I just rectify that? So this is in tab 47, page 976 is the relevant paragraph.
100?
Page 976.
Yes, it's paragraph 100.
Paragraph 100, please, my Lord.
This comes close, doesn't it, to saying that where you get an award of damages for a human rights breach, that unless the costs of obtaining that have been incurred recklessly without proper justification, you should also get your costs. I mean, you don't shrink from the breadth of that proposition.
No, it follows from the requirement to provide just satisfaction for the state's breach. If any other order, as we've seen, without the justification, I accept those justifications mirror our own unreasonable level of costs or not necessarily to be represented, etc.
Or you lost on an issue or something of that sort.
Well,
or was that not?
I don't think it goes as far as that. I think
proper
it
justification.
Sorry.
There might be proper justification
Indeed.
in the fact that, for example, the costs had soared because of
5 grounds that failed and 1 ground that won.
Exactly, that sort of thing.
Yeah. So I think the court makes allowance for that, in perhaps not in that statement itself, but in other dicta that we've seen, where the justifications for reduction can be provided by reason of an objective to prevent an exaggeration of a claim. So what we would perhaps think of as dishonest claims, and for poor conduct in the proceedings that increase costs. But they are specifically, when they do talk about that, about you've caused the costs, so therefore you bear the responsibility, and not simply sort of not recovering without that justification, without that cause. That does seem to be a clear principle. That you're entitled to your costs to the reasonable level, etc., etc., so that you don't lose your damages in that way.
As I understand it, Mr. Rule, I know this is often the point I'm making when I ask you a question, but what's happening here is they're focusing on a state authority. They're not focusing on the possibility of a similar situation arising out of a judicial decision. They're just not concerned with that.
That's right in some respects. So what we have seen in terms of Moscow, for example, was a case where it's the decision not to award costs, which is the violation of Article 6.
Right.
Rather than another form of violation. So it is a judicial order. It's an organ of the state has failed to provide the costs, which causes the violation, because you're then left without the recovery.
Right.
So, my Lord, whilst I recognise the relevance of judicial act in terms of, or judicial decision rather, in terms of the Davies principle.
Yes. I know you say that doesn't. I understand that your point is in this case it's not one. I do understand that. You don't need to go repeat that. I get that.
Yeah, sorry,
that's okay.
Thank you. So, that I think was the other paragraph from that, and then one.
Sorry to interrupt, Mr. Rule. While we're on that point, are you going to refer to any social section 9.3 of the Human Rights Act?
Yes.
Right, you are going to.
Yes.
Okay.
So, my lady, I'm sorry, my lady. That provision, to highlight it, so you know where I go, we submit that provision demonstrates why, for damages for this type of situation caused even by a judicial act, Parliament intends that there be available damages by way of just satisfaction.
I just wanted to flag it up.
No, it's a very important provision. I should have probably mentioned it already, but
always develop your submissions at the appropriate moment. But I just wanted to put that out there, as it were.
I'm grateful.
Thank you.
So at this point, can I go briefly to the Grand Chamber decision in Scordino? That's tab 25. Underlying background to the case, it was an Article 1, Protocol 1 piece of employment property possessions case with an issue about reasonable time, etc. The relevant passage at page 357, this paragraph 201. And I don't think this is something unlike that which we've seen before, but it's important that it's Grand Chamber authority that I mention it.
So what was the issue in this case? It's just helpful
So
to
it was-
know, so we can context for the statement.
Yes.
So this is a case
part of
about
the-
delays in the hearing cases or something.
Yes, I think it was the underlying dispute over deprivation of property by the state. There was proceedings against that, and then there was the effectiveness or speed. There was some retrospectivity. I think it was a slightly complicated set of facts rather than just a delay case. But if one goes to headnote page 311, you've got the reasonable time requirement as one of those. We haven't quite reached that portion yet. We're still in the victim status and remedies portion of the judgment, but there is a right to fair trial reasonable time requirement was one of the breaches. So the court's looking ahead to that type of thing before it gets there. And then one other factor of note is on page 371. Paragraph 271, the court decided that the government should pay a further sum where the applicant had to endure a delay waiting for payment of the compensation due from the state. So the frustration arising from delay in obtaining payment is offset. So I think that really augments the issue about it being necessary for just satisfaction to be provided as soon as possible and without building delays into the system. That may have bearing, for example, on procedural transfers and that sort of thing that delay somebody receiving their redress. The next case that's relevant to note is College and Croatia. This is our tab 46. The point that this case deals with is one I haven't touched on yet, but it's the meaning of success when evaluating costs order to make. And what the court is clear about is that success is qualitative, not quantitative. So it goes back to claims where you don't recover your full amount, but you suffered a violation of your rights, and you're seeking the costs for having brought the claim that demonstrated that fact. Page 952. Sorry, I should probably start at 948 so that the court can see we have the general principles drawing on Zubac, things that we've seen before. 44 confirms this. The court has confirmed a restriction on the right of access to a court cannot be regarded as per se incompatible with Article 6, Stankov. However, the amount of costs assessed in the light of the particular circumstances of a given case is a material factor in determining whether or not the person enjoyed the right of access to the court. See Klaus, I think we've seen that one. And then the weighty reasons to justify a result in which the entire amount is lost is paragraph 46. In that case, there'd been the wrongful quantitative approach because at paragraph 49, the applicant's claim was deemed well-founded and he was awarded 75% of the final claim in damages. At the same time, there was a costs award in both directions, I think, paragraph 50. And so he was going to have to pay double the amount he'd been awarded in damages. In addition, at 51, he had his own costs of representation. He was only awarded half of his own costs. So the court examined at 52 whether there are particularly weighty reasons to justify such an outcome. Noting access to court guarantees applied with equal strength to private disputes as to those against the state. And the fact that it was a private party defendant there was only a factor in assessing proportionality. So it didn't completely throw out the bath that it was a private defendant rather than state defendant. Similar principles of access to justice there. And the court then dealt with the award of costs and found a violation. Insufficiently convincing reasons have been put forward. Paragraphs 58 and 59 on 952. Even though it's a rather different case, private defendant, etc., it's worth noting, given in this case the claimant had assessed that he might have a slightly longer period of unlawful delay or a slightly larger sum of damages by way of relief. No costs were associated with that. And qualitatively, he certainly succeeded. This hasn't been challenged. So where we respectfully submit the European jurisprudence takes us, and that's one further case which I'll just mention rather than take the court to it. The case of Jakubowicz against Lithuania is our tab 51. That was a case in which the court upheld the refusal to reimburse costs after a drink driving offence where the person was acquitted. The sum of money involved was €1,500, and he had received what he paid for with that money. He was not fined and didn't have a driving licence ban. They were simple proceedings that didn't need specialist lawyers, and his civil claim against the state officers for unlawfulness was rejected and essentially brought prosecution upon himself. He drank vodka, went in the car, was breathalyzed, it had a reading. He was prosecuted, he came up with a blood sample he had done at the hospital, and on that basis, on appeal, managed to succeed. So that doesn't provide, it's a second section judgment rather than any high authority. It doesn't do anything other than exemplify that you can bring a case upon yourself and not be entitled to your costs. That's a long-standing principle of criminal cost proceedings in this country, albeit it's rare to apply it on the facts there. One can see exactly why the court did. That then completes my trawl of the DCHR authorities for the purpose of demonstrating what the Article 6 principles to be applied are. Where that brings us to, if I can draw that together, is firstly, we've got here a claim against the public authority, these various factors that we say are supporting the appellant's case. Secondly, a violation of the right to liberty, which is fundamental. Thirdly, one has the vulnerable position of those detained by the state, so that access to justice assumes an even greater importance. And it serves, of course, a private interest as well as a public interest in ensuring standards of lawfulness in detention, custodial power. Fourthly, it's proper to incentivise public authority defendants to concede proper claims. That's clearly in the public interest. If you're liable for costs, you've got to think carefully about whether you concede the claim or not. And it reduces costs overall in cases having to go the full distance. Fifthly, it's proper to ensure there remains available to prospective claimants who are victims of such violations by the state a pool of legal representatives able to take on the claims of indigent clients. There will be those for whom legal aid is not available. There will be those for whom it is. There needs to be recovery if you're going to be CFA funded because you don't have a sufficiently valuable claim to make it worthwhile, for example, or something. If anyone's going to take it, there needs to be cost recoverability in principle. The sixth factor I think I'll come to is the state body has funding available for its own representation, so there's an equality of arms consideration. Seventh, the practical issue I mentioned earlier, the Secretary of State and Lord Chancellor in fact funds by grant of cost the parole board in any event. It certainly has resources, the state's full resources. Another point I mentioned earlier, but I put in my list if I may, is the arbitrariness of largely unforeseeable. Is the breach going to be that for whom the parole board is responsible, culpable, or is it going to be the Secretary of State? You may not know that at the outset. Should ability to recover costs depend entirely on which defendant claims the other or which what the evidence later displays. And finally, one has to, of course, consider in the individual circumstances, as the court makes clear, the financial position of the appellant, so there's not an excessive financial burden on him, and the proportionality of costs and damages, etc. Here, the court has the information from at the outset this morning. I don't repeat any unless the court wants any more detail from the supplemental bundle, the essentials of what the costs were, the legal aid rates, and the financial situation of the appellant.
That's available to us. It was or wasn't available to the judge.
The learned judge didn't conduct an exercise of considering the proportionality of it, so didn't have any of it. He would have known legal aid was in place. That would have been in the bundle. There would have been a certificate there. Any more than that, I think I can take instructions, but I think the answer is no. That was the extent of what he would have known. It was a legal aid client, but that expressly isn't part of why he made his decision. As he says in his decision, that doesn't make a difference. Legal aid or not, same principles apply. So I think there was very limited information available to him. Had he wanted to conduct that exercise, he would have needed to.
But let's suppose it got to the point where, in a normal way, you're the successful litigant, you get up and you ask for your costs. Normally, I would presume that you then, the judge knows you're legally aided, but the judge is then informed in order to carry out these various exercises that you've given us £10,000 and our costs are X. But it didn't never reach that point in front of the judge, is that it?
No. In fairness to the learned judge, I think, being fair to his judgment, he simply said, Davies, parole board, you don't get your costs unless there's two exceptions, unreasonable failure to concede or activity in the claim. And I decided, and we challenged this, but his lordship decided that that neither of those two exceptions applied. What wasn't there was the consideration of Davies 47.4.
Right, so you say that I mean, we'll come to this at a later stage as well when you come to your ground 7. You say that the judge's approach was reductive in simplifying to some tramlines the decision that he had to take rather than looking at it more widely. Yes. In the way that you said you should have done.
Yes, and I wouldn't criticise Mr. Justice Fordham for that because it's a common conception, and that's part of the issue. My submission with
I was putting it in the same way. It wasn't Mr. Justice Fordham. It was a judge performing this exercise would be
indeed
reductive.
Yes, indeed. In all fairness to his lordship as well, as he points out, he didn't receive much additional assistance beyond the 20 pages of the original submissions. So the appeal submissions certainly were very short. He did. But in fairness to my Lord Junior, there was a request in the longer document for the proportionality assessment and the Article 6 grounds. So the judge was invited to do it, but he appears to have taken the view on the reductive basis. That's not something I do, given that we have the rule of Davies interpreted in that way. So
was he given the material to do it if he wanted to?
What I'm conscious of is that there was a judicial review bundle which had the information about the appellant. I very strongly suspect it would have indicated he's unemployed, he isn't a man of means, etc., and his intellect the judge was aware of, because you can see that in the judgment. So there would have been information about the nature of the financial circumstances of the individual, albeit not necessarily the same.
Surely you should have given him the information about the cost.
Well, there's a cost schedule. The cost schedule would indicate a vastly larger sum than the 17,000 because it's calculated at reasonable client rates, reasonable private rates.
So was there a cost schedule?
Yes.
Sorry, do we have that?
No, but it would be at inter partes rate. So the reason we focused on legal aid is the statutory charge argument that's put against me is that if there's no inter partes recovery, the amount the appellant would have taken away is the 17,000 odd legal aid.
So in what shape or form did the judge get a costs schedule at inter partes rates?
I think it was a normal schedule. The N260 is it?
Because I just can't remember what the sequence of events was. Could you just break it down between argument, judgment, decision on costs, and how did it actually go in real life? I'm sure Mr. Beckett can easily remember.
There's a costs application, which you can see at page 111 of the core bundle. In that application, paragraph 4 referred the judge to an alternative order being disproportionate, unlawful interfering with the claimant's rights. Effective remedy, Article 5.5, obligation. Asked to examine the application of the Davies Rule, paragraph 6, for compatibility with convention rights in the context of proceedings leading to an award of damages in respect of a judicial act compensated pursuant to section 9. Paragraph 11, I mean, the principles which we've covered. Paragraph 11, the rule is particularly strong in cases requiring successful parties to bear their own costs would amount to an excessive financial burden. The amount of the cost exceeds the compensation. Examine on a case-by-case basis, paragraph 12, fairness, proportionality. The paragraph 14, 114, the claimant is publicly funded, the current limit of 15,000, it should have been, I think, 20,000 already by then, but the old certificate was presumably in the bundle. 15,000 under this certificate exceeds the award of damages in his case. It will impose considerable financial burden.
Right, so the sequence of events was that this is dated the 20th of February, and the sequence of events as seen from the judgment is that there was argument on the 11th of February, draft judgment on the 12th of February, and the final hand down, which includes the cost ruling, on the 27th of February.
I think that's correct, yes.
And so and as the judge says, there wasn't a hearing about costs. He considered the written material before making his decision. And we've also got the Parole Board's submissions in response.
Indeed. So I was just taking you to the submissions he received before that first order,
Yeah,
and then
this does or doesn't disclose whether included in the materials was the costs schedule. How did that find its way to the judge? Presumably at some time during this process.
my Lord, just conscious of time, can I just pause at this point and say there is a large bundle of material the judge had, which this court doesn't have. If the question the court is really asking is, was the judge entitled and able to make a decision other than he did, which is to ask about proportionality?
It's a purely factual question as to whether, as part of this exercise in seeking to get costs, amongst the documents the judge was given was a cost schedule. That's all I want to ask. As a matter of fact, I'm not drawing any conclusions from it at all.
I will take instructions about that. I don't want to misspeak. I've seen at some point a cost schedule. It's at inter partes rates. My expectation, because of its production, was
I'm
it would have been
wondering whether it was shared with anybody. That's my question, and sooner or later you'll be able to answer it.
Yes, I'm sure the answer is yes, but I don't want to say that without knowing the answer is yes. So I will check if your lordship wishes on that point. So
Please do.
So I'll come back to that. I'll leave that in capable hands, and then we'll give the court the answer. The point that I'm addressing from the authorities is the obligation to provide a reasoned approach, the sufficiently convincing reasons, as the court said. It was enough not to have weighty reasons why you don't recover your costs to be a violation, and the provisions of information the judge had, including a wealth of information about a serving prisoner who's been in custody for a long time, who has no financial situation or employment, and the scenario in which he's considering, the situation in which he was told, the entirety of damages will be gone in costs. So for far as principles to be applied, any proportionality assessment, had he chosen to undertake it, but obviously he didn't, and that's not in dispute, would have been one which identified that all of your damages for your unlawful violation of liberty rights will be gone in cost to the state for having loaned you your legal aid. That would have been the assessment, and the judge would have been obliged to consider, is that in pursuit of a justification that the reasons for the decision speak for themselves with judicial impartiality or independence? The answer the judge must have come to would be no. It doesn't pursue any legitimate aim, because that's limited to independence of a judicial body, not to failing to provide a hearing on time. That absence of legitimate aim would be enough. And even if there had been a legitimate aim, I would have to consider the proportionality of denying you any redress for your unlawful detention as a person of no means for whom this would make a world of difference. So the answer would be, in my submission, an obvious one following the jurisprudence that he must of the Strasbourg Court to identify what would be the appropriate response. So on the particular circumstances point, I think we've seen that sufficiently. If authority were needed on it, Lord Lloyd Jones in the Imperium Trustees case is our tab 55, and that case dealt with Belgium requesting tax information via the competent authority in Jersey. There was a statute that said no costs. And in that case, in fact, the judicial review wasn't finished. Article 6 wasn't engaged, which was the dispositive point. But over to dicta, we can see that if you're challenging, in that case, legislation, which is of course different, it would be an individual assessment rather than just in the abstract, as it were. So that's paragraphs 80 and 81, page 1216. But I think on the point of individual assessment, more useful, I'll just ask the court to go to that Johnson's case I mentioned, the Northern Ireland Article 2 inquest case. That's tab 42.
Jordan's.
Yes, please, yes. Page 840, just two paragraphs that I'll draw attention to. Under the proportionality restriction on access to the courts, the court at the end of paragraph 33, as the Lordship says, as will be explained, the exercise requires consideration of the circumstances of the individual case before the court as to whether there would be a breach of Article 6 in terms of proportionate restriction on the right of access to a court. And interestingly, he's differentiating that part of Article 6 from the reasonable time part. There might not be a reasonable time breach, but there might still be a refusal of an impediment of access to the court, which couldn't be justified as proportionate. So there are two aspects to Article 6 that delay could arise on a particular case. And at paragraph 38, his Lordship was clear that there's no doubt maybe cases in which it's proportionate to stay some of those legacy cases. Equally, no doubt, many cases, it may be cases weighing those factors stay is not proportionate, so there needed to be a necessary balancing exercise in the individual case. There wouldn't be any virtually automatic rule requiring claims to be stayed. And the court below had failed at paragraph 39 because on its face it involved no assessment of proportionality or consideration of individual circumstances. So the emphatic principle must be that you cannot have a virtually automatic rule not to apply mutatis mutandis, not to award costs, and not consider the individual circumstances that would lead to a breach of Article 6 on a balancing assessment. So, my Lords, my Lady, if I may go then to grounds 3, 4 and 5. So that's 1 and 2 covering the ECHR Article 6 aspects introduced to the regime and what it informs in terms of Davies 47.4. For 3, 4 and 5, this is the issue about whether it really does apply to circumstances of this nature, although ground 6 then goes further with 5.4. But the starting point we submit is to identify what is the purpose or legitimate aim that is being invoked. We've been through Davies and Gourlay already, so we looked at that, the reasons for the decision being there. The Parole Board's cost submissions below, the court's mentioned those. They're at page 119 of the bundle, and they said that the claimant was asking to depart from established authority, a position that was well settled, the settled authority of Gourlay. Didn't deal with the cost issue as one which required any consideration, as if the answer is no costs ever against Parole Board, save for the two exceptions. Some case law that's been cited, and I'm conscious I want to come to section 9 the Human Rights Act very shortly. Just before I do, one case that's worth noting is the CZ human rights claim, cost decision of Mr. Justice Cobb as he was. This is our tab 38, please. This is the decision which concerned costs being sought in relation to two separate types of proceedings. One was family proceedings, subject to the family proceedings rules and their cost provisions. The other was a Human Rights Act action, which was brought and successfully pursued to some extent. The issue, well, the first thing is that on the point of principle, that where, despite it being before the family court, where the Human Rights Act claim was brought, it was a civil claim under Section 7 of the Human Rights Act, and the CPR rules applied to it. So it didn't matter that you were in a different forum. If it's a civil claim of that nature, that's the applicable rules. Just to show you that, that's page 752. Lordship's decision at paragraph 61. The parties, I don't think, had presented it in that way, but his lordship was clear. It's one rule for the civil claim, one rule for the family proceedings, and then dealt with what had happened in relation to that. So just to go slightly further back, you can see there had been an offer to settle the Human Rights Act claim made by the local authority. That is at paragraph 35 to page 744, Roman numeral 2, right at the top. The cost of the Human Rights applications from April 2016 issue to 14th July 2016, when there was an acceptance of declarations and a proposal to settle. This was part of the cost the local authority was offering to pay. So it was accepted the local authority would pay those costs. Back over to the previous page 743. So the issue before the court was what about the costs after that period when there was negotiations, who was the reasonable or unreasonable conduct in the negotiations. Question was raised over whether section 25 could apply to waive the statutory charge. That wasn't possible. Just mention that for completeness, paragraphs 47 and 48. And he referred to the loan of legal aid at paragraph 49. Those are on page 748, 749. But the legal aid had nothing to do with it. What was relevant to the decision that the court reached was the conduct in trying to settle. So if we go to paragraph 58, page 751, Roman numeral 5, the evaluation of costs, I'm obliged to have regard to the party's litigation conduct, whether costs are reasonably or not reasonably incurred. Claimant's approach would require me to ignore or forgive any reckless, wasteful or profligate manufacture of costs in order to ensure the claimants receive their award. This cannot be right. In this case, as will be apparent from my comments below, the claimants did not conscientiously attempt to settle their claims, whereas I'm satisfied the local authority did make genuine efforts to do so. And this influenced my approach to the second argument below. conclusion, paragraph 66, page 755. Consider the claimant's litigation conduct as such they forfeited their entitlement to costs. So one reason, as I've accepted from the outset, this court knows that you won't receive your costs is your conduct in unreasonably, in that case, refusing to settle. That was a finding open to Mr. Justice Cobb, which he made and applied. And similarly, the case of Turkey, TIRKEY has been raised, tab 39. This was a case where the claim was based on non-satisfaction of an employment tribunal's award because the employer, a private individual, had dissipated assets to avoid satisfying judgment. The court there noted, Mr. Justice William Davis, as he was, noted at paragraph 27, the bulk of the claim was pecuniary. There was legal aid for pursuit of the recovery of the award. There had been pro bono employment tribunal representation, but legal aid had been applied to recovery of the award. But the reason why there wasn't recovery of the award was it was simply the practicality that despite the court giving an order for costs in the enforcement proceedings, the fact that a private individual didn't satisfy it wasn't the state's responsibility. It was the fact that there hadn't been, as a matter of practicality, someone at the end of your civil claim to pay the money. So on that basis, the charge to the loan from legal aid didn't come into, wasn't something which was the state's responsibility, and that there hadn't been satisfaction of the claim despite the state's orders. So paragraph 31 on page 770, point is to put you in the same position as the private individual. So Article 6 ensures proper access to justice. Statutory charge didn't interfere with access in this case. The eventual result was that the claimant didn't recover any of the damages awarded to her. That was because the Chandricks cynically disposed of their assets after the first decision was reached, and because the proper steps taken by Freshfields to enforce the judgment failed due to delays in the county court. The sensible interpretation of Article 6 provides a guarantee that it will recover her award of damages. The aim of the statutory charge, 32, is to place the legally aided litigant in the same position as the litigant who does not have the benefit of public funds, is able to fund the litigation from her own resources. So that comparison meant if you were paying privately, the same position would happen. If you paid more than you get in, that's not the state's fault. That's because, despite the order in your favour, the other private party has dissipated their assets.
What do you make about the first and last sentences of paragraph 31?
That's because of the context which I've been referring to. This isn't an action against the state body who has the money to pay you, and it's the order of the court that's failing to give you your redress. It's the simple practicalities that the legal aid is there as a loan in the same way as a private individual fund. So it's there to provide you with the same access to justice as the private individual. If the private individual spent out to get money in but doesn't then recover, you're in the same boat as that. If the private individual you're suing doesn't have any money, you can't, by taking legal aid, put yourself in a better position than if you'd been privately. That principle just doesn't come into play here in Mr. Fitzgerald's case. In either the private or legal aid claimant in Mr. Fitzgerald's case has an identifiable public authority who's breached his human rights, who has the money to satisfy it, but it's the court's failure to award the costs, which means he doesn't get his redress and his just satisfaction. So it's incomparable to a private individual fails to satisfy your judgment. The position that there is some privileged position for the parole board not to meet the costs in this case is, as was adverted to earlier, at odds with the structure of the Human Rights Act and the principle of equal access to effective remedies that Parliament has enacted. So by a practice of the court, not a presidential one as we know, but a practice as to costs, etc., applied in this way without the individual consideration or the proportionality assessment, that is a breach, firstly, of statutory duty under Section 6 to make a compatible order, public authority including the court. So it must act in a way which is compatible. If authority were needed on that, we've included Lord Bingham famously saying the same in Attorney General's reference number 2 of 2001, paragraph 30 on tab 22, page 229, but I take that principle as tried. In the appellant's case, the order is in breach of Section 6 because it is disproportionate or doesn't pursue a legitimate aim, and it's incompatible with the approach that Parliament intends from Section 9.3. So could I invite the court at this point, and apologies that it wasn't sooner, but to Section 9.3, tab 5, page 31, please. So a few things to note from this provision. Judicial acts, Section 9, proceedings under Section 7.1 in respect of a judicial act may be brought only by exercising a right of appeal or for judicial review or as prescribed by other rules. And subsection 3, in proceedings under this act in respect of a judicial act done in good faith, damages may not be awarded otherwise than to compensate a person to the extent required by Article 5.5 of the Convention, or to compensate a person for a judicial act that is incompatible with Article 6 of the Convention in circumstances where the person is detained, and but for the incompatibility, the person would not have been detained or would not have been detained for so long. An award of damages permitted by subsection 3 is to be made against the Crown if they're joined to proceedings. Now, that provision therefore indicates that there is no principled objection, even though a judicial body must be independent, impartial, must be able to let its reasons speak for themselves when a superior court is reviewing that body. Nonetheless, Parliament intends no immunity from liability for a good faith decision, judicial act, that has led to an infringement of Article 5.5 or led to a prolongation of detention incompatible with Article 6. So that in my respect, submission goes a long way to allaying concerns that there would be any contrary intention of the structure of human rights protection in this country to allow a practice to be applied or to persevere with cases of this nature. And whilst it's not in the bundle, I'm afraid, it's been brought to my attention over lunch that, in fact, in relation to this section, there's also in the CPR, Rule 7.11, which states that if proceedings are brought under Section 70 rights against a judicial act, which would therefore invoke Section 9, they may only be brought in the High Court. So CPR Rule 7.11. And that may have some bearing on what amounts for judicial act or not, or on the fact that the cost rules would be those of the High Court if such a proceeding is brought by virtue of the requirement that this is the location for its issue.
Presumably that wouldn't prevent, say the proceedings were divided into a determination of liability. If the High Court decides that the public body is liable, presumably the assessment of the compensation could be transferred to the county court, could it, or not? I mean, maybe it may not be relevant, but
I don't see any reason why not. If the wording, I haven't got it in front of me, but I've written down maybe brought. I think it's brought.
Yeah.
So if brought, there could be, for example, you have that with certain immigration matters that end up in the upper tribunal but begin in the High Court as judicial review.
Age assessments.
For example, yeah, where there's interim relief, the court deals with that and then typically transfers the fact-finding hearing over to the tribunal.
Certainly, by my recollection, Part 7 is about starting proceedings.
Yes.
It's about where you start them.
Indeed. So there could be process by which starting proceedings is then subject to transfer.
Well, the rule says exactly what you said, of course, which is that if it's in respect of a judicial act, it may be brought only in the High Court. Any other claim under Section 7(1)(a) may be brought in any court.
Yes. As well. So there's that differentiation of judicial act in the rules in that way. The other provision.
Does that mean that in this case, if the act in question in this case is a judicial act, then you shouldn't be getting damages against the parole board, you should be getting damages against the Crown? I think it does, doesn't it?
It suggests, it can be read that way. The difficulty with reading it in that way is that typically that isn't what happens. And there is
well, obviously, it's about the damages. It's not about saying that it's not the right thing to do to judicially review the parole board and have them as the respondent to the judicial review, in the context of getting a declaration that you know the prisoner in this case would need to be released or whatever. That's not a problem.
Can I?
It does make sense to me. I can understand why, actually, if you think about it, why a statute might very well say that in respect of a judicial act, it's the Crown that is the one that should be paying the damages.
Indeed. May I offer this, because my submission is that an Article 5(4) delay is not a judicial act. The only time that damages would be being applied to the parole board in respect of a judicial act would be if it was a different type of award. So the awards for delay, and we haven't come to Faulkner in the Supreme Court yet, but there is authority that differentiates. Realistically, when awards of damages are made, it's typically when detention has been prolonged or the anxiety or distress of not knowing your outcome has been prolonged by delay about that decision, rather than procedural errors that might otherwise breach Article 5(4), but are about fairness, not about delay. So if the appellant's submission is correct, it is not a judicial act. There's no impediment to the award against the parole board in terms of the statute. It's not a judicial act. It's the parole board's responsibility, which is typically how it's operated, that it is the body that pays the damages and it's reimbursed by the Secretary of State. Yeah. Sorry.
I was just going to say, subsection 4 says an award of damages to be made against the Crown, no award being made unless the appropriate person, if not after the proceeding is joined, appropriate person is then defined in subsection 5, and that presumably would be the Secretary of State who was originally joined in the proceedings anyway.
Yes. It does, just to offer this also, judicial act means a judicial act of a court. Of course, typically the Lord Chancellor has responsibility for courts, and a court includes a tribunal, but typically there is that line of responsibility and oversight in that way, whereas with the parole board you are dealing with a non-departmental body. So perhaps we're back to the quasi-judicial having some meaning, because it's not as straightforward as a judicial act of a court or a tribunal, which is within the structure of that system.
The fact that the parole board counts as a court for the purposes of Article 5(4) isn't an answer to the question. It's simply the way that this country has decided to abide by Article 5(4) by appointing the parole board, an independent body, to make decisions about the. I see what Jimmy is doing.
Precisely. And we have included Section 239 of the Criminal Justice Act, which creates the board, or followed that 1967 Act, which originally did, but it creates it as a body corporate. So the board making a decision, whether it's judicial or quasi-judicial, isn't actually a court or a tribunal and constituted in that way within our structured system. So not subject to the Lord Chancellor in the usual way tribunal and court system has that supervision.
So there may be a court. The court may have an autonomous meaning for the purposes of Article 5 and a different meaning for the purposes of Section 9.
Yes.
Deep waters.
Right.
Also, I was looking at the definition of judicial act again, which is defined as a judicial act of a court and includes act done on instructions or on behalf of a judge. So I'm going to address this a little more, are you, as to what was happening here in this case.
Sorry, my lord, I didn't follow.
So I'm just trying to fit the statutory definition of judicial act. Trying to understand what your case is as to what actually happened in this case. And what
My case is not a judicial act, it's an administrative delay. And it's a delay, listing maybe judicial responsibilities, etc., but at a body that has an administrative delay, which is the term used in the probable zone guidance, which I'll come to, but that delay is not a judicial act. It doesn't, and that's why it has no application of the idea that you leave the reasons of the judicial decision, for Davies' point, and for other points, it's not a judicial act to fail to provide a hearing
Right, so,
on
I mean,
time.
could we
Simply
just
a
take
failure.
examples? Let's suppose an undoubtedly judicial act, which is that the papers come in front of a judge or there's a hearing and a judge says, I think this is a rotten claim, and I'm going to order that it isn't to be tried for at least 1 year. You with me?
Yes.
I mean,
So the
Not a very
question,
likely scenario, but in other words, that there's a deliberate decision to offer, well, it might be a short date in the Crown Court, but a long date in most circumstances for a long time, a decision to simply put you on the back burner for a long time. That would be a judicial act, presumably.
my lord, I prefer to express no opinion on it. It isn't the scenario in this case which leads to an award of damages for Article 5.4. So I think it's a difficult issue that
I think it's
doesn't.
difficult for you not to express an opinion about it, because we've got to have some understanding about where the line is to be drawn between judicial acts and other sort of acts, because the expression a judicial act of a court, which is the definition of a judicial act, leaves one to ask what are not judicial acts of a court. What does a court do that is not judicial?
Well, this case we say is an example of what is not a judicial act.
Yes.
This is a failure to provide a hearing.
Yes, well, I understand that that's your submission, but I just want to know at what point might the line be crossed in the other direction.
My submission is it's unlikely to be ever necessary to look at any other example, because the only time that damages is awarded is when it's the non-judicial act of a delay that's in breach of Article 5.4. The proposition, my lord, the question my lord puts to me is the difficult area where there could be a judicial decision to cause an unlawful delay.
Yeah.
If that's a judicial act or not, I prefer to express no opinion, because I don't. For the present purposes, it's not the situation. This case is the simple one, where you have a non-judicial act of simply failing to provide public authorities obliged duty of a 5.4 hearing. So it's not something which I have delved into in the way that I need to answer for that question. So I prefer not to express a firm
just
opinion
to
on it.
be absolutely clear, Mr. Rule, as far as I'm concerned, I find this distinction very hard. And the reason I find it hard is probably because I'm a head of division and responsible for the listing officers in the Chancery division. And I rather think, until I'd listened to you, that they are acting under my delegated authority and making listing decisions every day, which involve not listing some things and listing other things. And I certainly have always understood that I ultimately bear responsibility for them. And if there is any doubt about it or any question arises, of course, they come and ask a judge. But most practical listing decisions, which includes non-listing decisions, which are called administrative by our court service. We all call them administrative in that sense. They are administrative, but they are under the delegated authority of the judiciary and an individual leadership judge in any one case. And I must say, I don't find it compelling every time you say it's administrative, that is a simple answer to the question. And whether the parole board is actually a court, that's a different thing, and I get that. But if it is, as the authorities appear to be, something that you treat as a court, I've got a real problem with the argument that because this is a non-listing, that's what happened, it wasn't listed, that is obviously not a judicial act.
Well, firstly, there's no comparison. I understand my law's point entirely. There's no comparison. The Parole doesn't operate like that. It doesn't have a judicial member who is supervising the listing or responsible for supervising listing. It has officers who are going through a tranche of cases. They look at a date on a system and they put stuff through. They're given insufficient resources to list all the cases that should be listed, and we end up with a case like this.
Well, I'm given insufficient resources to list every case as fast as I would like to. I mean, I'd love to list lots of cases quicker than I can.
We haven't included Norcoive. Norcoive, because the judge accepts it, it's very well established. It's the Court of Appeal saying lack of resources does not apply to 5-4 parole board mechanism. You can't rely on it. So, but that's different because you can't rely on it. It automatically isn't a lawful excuse. The reason that was given, I think it was Lord Wolfe, the reason that is given is it's the state has chosen to detain people under this structure.
Look, Mr.
and it
Mr.
has to
forgive
provide
me.
hearing.
I'm not disputing with you that it wouldn't be a lawful excuse. That's not the point. That's not the police. I don't see it as the point. I get that if I was that person, just a person, let's not personalise it anymore. I get the point that it isn't a lawful excuse, but that's not the same question as what sort of decision is it.
No, that's fine. My first point is the parole board is a body corporate to be distinguished. It doesn't operate like the courts. My second point is it's a bit of a distraction from the key point. Is there a justification based on the Davies analysis that for the independence and impartiality of the court, there may not be cost recovery if a court stays independent and lets the reason speak for itself? Does that have any application to an Article 5.4 delay without a judgment or decision that specifically does it? Answer is no, it doesn't have anything to do with it. So that's why, rather than me get too involved with judicial acts or not, it is not anywhere near being a judicial act that would have anywhere near the attraction of an issue of independence or impartiality. It just doesn't engage on any realistic level, doesn't engage those points. So I might have to engage with it if there were a decision that had caused the delay, and I'd have to look at my Lord's point. But on the basis simply of what we're dealing with here, which is a delay without a positive judicial decision creating that delay, and in the context of the parole board body corporate, there's no justification for a rule that denies recoverability. And that's what this case is about. So the absence of justification for not allowing recovery is the issue, and whether or not one wants to describe it as administrative or judicial, it's not my words, it's administrative delay. That's what it's used. It's what the parole board calls it. In any event, there is a distinction between the court system and the parole board's structure. It is treated as the court for the purposes of complying with our statutory obligation to have an independent panel overview detention legality. It's not a court in the court structure. It's not a tribunal in the tribunal structure. And so to that extent, those have to be borne in mind. I'm conscious of time. The Faulkner Director of Legal Aid case was a partial win where conduct-based and flexible rules meant that they had an issues-based cost approach that had been correct and justifiable. It does say in that case about the not being able to apply for the waiver after. I think I've dealt with that, but for completeness, it's paragraph 18 of Lady Justice Aspin's judgment. The points on this distinction of Article 5.4 and delay cases, the court, I think, would benefit just from me taking you very briefly to the Faulkner and Secretary of State Parole Board case. This is the case that identifies why damages are available for those specific cases. It's tab 31. Page 525. There's a lot of analysis of the European case law on when damages were required or not for Article 41 satisfaction in Article 5.4 breaches, and the conclusions that the court reaches, you can see it. Page 525, paragraph 41, damages for delay breaches are in a very different category. that distinction is made clear at 53 and 54. And 59 and 60. But all, I think, just to that point, so the court has the reference there, that's the point, that delay is different. I've referred already to the point which I'll raise again, which is the artificiality of distinction between who causes the delay. Is it a judicial act because the parole board hasn't given you the hearing, or is it a non-judicial act because the Secretary of State hasn't given the parole board a report for a hearing? And does that make a difference to the state's obligation to meet the costs of remedying the Article 5.4 breach? My simple submission is, on principle, there's absolutely no justification for that at all. None's been suggested. And the parole board policy, as I've mentioned, in the recently provided bundle, there are two policies, the 2023 and 2021 policies. The 2023 policy, firstly, page 6 of the internals, page 51.
Sorry, which bundle are we in?
Sorry, well, the supplemental, second supplemental.
Second supplemental, thank you. 51.
Please.
Paragraph?
.14 is the parole board's general point about, as Lord Reid said, leaving the reasons to speak for itself, in apposite to a delay case, simple delay case.
So I'm being very dense. I mean, maybe I'm just being very literal, but 214 doesn't say reasons speaking for itself. I'm sure maybe it says words to the same effect. I don't know, but I'm just.
The Junior Court or Tribunal has made its judgment, given its reasons. The judgment and reasons will stand
I
before
see.
their own
Thank
merits.
you. That's fine.
Sorry.
That's all right.
Sorry, I failed to find this. I didn't get down the tab number.
Tab 17.
17. Thank you very much.
Oh,
According
sorry.
to my electronic version.
Thank you. No, it's my fault for
Second.
writing down a note about something else. Didn't process it. Thank you very much.
Just a minute, Mr. Orchard.
Please.
Could you just take us back again to what it is you'd like all three of us to find? Because I've got it on my screen and my lady hasn't got it on her.
Sorry, this is the authorities bundle.
No, this.
Oh,
Sorry,
sorry,
I'm in the
it's my fault.
supplemental hearing bundle. Can I?
No, no, it's
I have a hard copy if that would help. Hand up.
I'm looking completely different bundle, that's why.
Not to worry.
Yeah, that would be extremely helpful. Thank you. Sorry, I'm several skips behind the beat. Thank you very much. I have got a copy somewhere, but yeah, thank you.
And what paragraph? It was 214, wasn't it? Mr. Orchard?
Yes, 214 in the middle of that paragraph was the reference to reasons. .216, same page 51, recognised where it's not challenges to judicial decisions, it's more appropriate for the board to defend them. If you would. Page 8 suggests 2.21. Sorry, page 52, 2.21. In rare cases where the probable takes an active role, it will provide summary grounds of defence. It did do so here. And then 227, where it's taking an active part, it's represented by counsel, otherwise won't be present. It was present here. And then in the section that begins private law claims, It notes the private law claims compensation claim made by prisoners to parole without possible delays which have occurred will be alleged to delay breaches Article 5.4. It only applies to the indeterminate prisoners, as it refers to Faulkner and Sternum for damages assessments on page 54, and then you go through to 3.18, directions issued, judicial directions act to stay any breach. So the parole board says it acts to stay any breach if it makes directions. Of course, if they're lawful or unlawful, would be a matter for the administrative court, but it refers to those in the context of delays as well. And then it deals with the payment of damages and costs. 4.2 offers
Sorry,
to
are
settle.
you going to refer to 3.21? That's potential. Is that relevant?
Yes, administrative delays, sorry. 3.21 on page 56. If a hearing is listed outside the target date due to a pure or sole listing delay or due to panel chair unavailability, the will generally accept breach as these are administrative delays. So that was the point that I was referring to in terms of the terminology that, in my respect submission, the board correctly takes about pure delay cases. And then there's provision made about when the board will or won't pay costs. There's no suggestion it shouldn't be liable to pay costs if a claim's been issued. It seems to take issue with paying them if the claim isn't issued and it settles it at the pre-action stage, but that's set out. But then payment of costs depends on proceedings being issued. Of course, that comes back to the question which I raised at the start, which is the proposition that you essentially can bring a civil claim as long as you're not bringing it by way of judicial review and you've waited right until the end and allowed the breach to finish itself. You then could bring civil proceedings and there'd be an acceptance of liability for costs. But the mere fact that you choose, as you're entitled to try and enforce your right and bring an end to the unlawful delay, the parole board says you're in the wrong forum for me to be liable for your costs. That underlies the lack of any objective justification for why the parole board shouldn't pay costs for a pure delay case.
I know that you're trying to make progress, but you mentioned very much in passing the other Faulkner decision, the decision of this court, after the matter had gone to the Supreme Court, which we have at 41. And I was reminding myself of what that was all about. I just want to give you the opportunity to help us in relation to what was happening there. And I think the easiest place to pick it up is probably at 820. There have been cross appeals in the Supreme Court that he ended up with a fixed award, which was going to be wiped out by the statutory charge. And you see that at 820 letter G. In
Yes. And I've marked up the same. I do appreciate. I went very fast over this.
I know you were under pressure of time, but it seemed to me that there was rather a lot of read across in this, and well, there might be. He's asking that the statutory charge should be waived. That was what the case was about. Is that he approached it in a different way, rather and. When dealing with that, what we said at 26, 27. Start at the bottom of 827. which is the human rights argument, and Mr. Southey's submissions at 26, which comes to a conclusion at the top of the following page, that his Article 5 damages must be protected in full and accordingly the statutory charge must be waived. Paragraph 27, the effect of his submission is that Mr. Faulkner must be entitled to the damages, whatever the substantive and the costs outcome of the proceedings of the Supreme Court must be ring-fenced and the statutory charge must be waived. Otherwise, he'll not receive full redress as a victim, and the state which breached his human rights in the first place will be giving with one hand and taking away with the other. So that was the argument that we heard about that. 31 and 32 traverses what was being what the court said about that, which was that although it contains an express right to compensation, indeed it's the only article that does, it was said that there's nothing to suggest that a breach is different from any other convention right. And that effectively, if this was right, then it would apply to any Human Rights Act damages, that the statutory charge would have to be waived. That's at paragraph 35 then. Legally aided litigant would be placed at advantage.
Yes.
And so on and so forth. Now, how are you distinguishing what's being said in that case from what we're saying in this case?
Because it's conduct-based.
It's
Conduct-based. It's an absolutely standard approach, which is compatible with the ECHR jurisprudence we've been over, which is if there's a justification for reducing your costs because you have unreasonably incurred them, you've increased costs with your actions, you've acted in a way where your conduct brings it on yourself, you're not entitled to an indemnity against all costs you might have come up with. What you're entitled to is your reasonable costs returned to you for having vindicated your right that you've succeeded on. So not beyond that, and not in an unreasonable, it doesn't give you a blank check to say I will put up costs unreasonably or I will take unreasonable points. So it's very much specific, and I can show you where I'm
just not sure what this is leading to, because if, let's suppose you were to succeed on your ground 7 point, which is that freed from Davies, the judge ought to have made at least some award of costs in your favour. Then you'd only have reached the starting line for Mr. Faulkner. I mean, that wouldn't get you across the finishing line. It would just get you to the point where you'd then be faced with the statutory charge. And then at that point you faced with our decision in Faulkner.
I haven't accepted that there's any finding by the judge below or any reason to reduce the costs from full recovery IP.
No, exactly. So, but let's suppose let's have you absolutely right, and that you succeeded in this court and should have succeeded below in getting an order for costs.
Yeah.
Right.
That's different to Mr. Faulkner. The reason it's different to Mr. Faulkner is he had a cost order against him, which is his complaint, because he took points which he lost on. So his complaint, and he wasn't able to use the statutory charge because, as Lady Justice Appellant says, at 16 and 18 it has to be the test case at the front, etc. So statutory charge is neither here nor there. Essentially, your loan has to be repaid because you have not, like any privately paid client, you have not recovered all your costs because of the way you conducted the litigation. Now, even if it's a human right involved, obviously there's a legitimate interest, and the court says it right at the end here, page 830, to deter them from running up costs unreasonably by giving them a financial interest in how the money's being spent. That's part of the approach there. So the reason that you receive a loan rather than a grant when you're a successful claimant is you're there to obtain the redress in the same way as a privately paying client. And the privately paying client could not insist on their full costs if they've acted in the way that Mr. Faulkner did by taking unmeritorious appeals.
So the distinction is that Mr. Faulkner is a losing litigant.
A partial. He's a mixed litigant.
He's a mixed, but he's a mixed litigant. But how does this affect some of the argument that you addressed to us this morning about the European court statements that you can't give with one hand and take away with the other. Very plainly, you can.
Well, they accept, my submission about the authorities is that they accept that if you've got a convincing enough reason, you can even reduce damages to zero if there was some really, really compelling reason. What you're obliged to do is to ensure that the successful person, without those reasons that we recognise in our system for removing your cost entitlement, why they shouldn't receive the costs that they incurred in going to reasonably take the vindication of their rights. So long as they reasonably take proceedings, i.e. act reasonably in the proceedings they've taken and reasonable costs, they should recover all of that because they have had to go to the expense of suing the state because the state failed in its obligations in the first place. But you can say, well, actually, yes, the state violated Article 5.4 and you brought proceedings, but you then decided to do things which added costs. We can't just give a blank check to that. There are limits which are reasonableness of costs. They could be assessed down, or conduct that means you don't get a full order for your, a split order on costs if you've acted in a certain way. So my reading of Faulkner, and paragraph 34 is really the key on this, is that the actions of Mr. Faulkner meant that he had incurred costs unreasonably. He didn't merely seek to defend his award damage, sought an increase, granted permission to cross bill on that and lost. So all of that was why he wasn't receiving his damages as this partial winner. And I don't take any issue with that. So I simply say that's, if this claimant, if the appellant had done the same thing and had an order 60-40 because he'd done something that he shouldn't have done, then that wouldn't be the complaint. The complaint is as a fully successful claimant,
right,
and without any costs attributed to you taking this other point that you lost on.
Right, so you're distinguishing fully successful litigants from partially successful litigants, and you're not complaining that partially successful litigants can end up empty-handed.
Well, if they do, it's
facts.
their own fault. It's their own fault. Because that's why there's an order of costs that they don't recover, because it's their own fault. So where you can't have in the European jurisprudence, the approach is to say you fully succeed, you're entitled to the vindication of the wrong that the state did you. In fact, you're entitled to the sum of £10,000 because of the nature of the gravity of the breach. That's a relatively sizable sum in ECHR award just satisfaction terms because it's Article 5, because of Faulkner and Stern are analysing loss of liberty. And on that basis, you're entitled to everything except for the fact that the defendant happens to be the parole board, and there is a rule that applies to judicial decisions, the parole board speaking for themselves to preserve its impartiality. I'm going to skip over, there's a case of Roach, which was one of those which was cited by the parole board to the judge below in the skeleton argument seeking transfer. There's no copy in the bundle. There are copies here, but it was a pre-permission case on transfer where there'd been a full admission of liability by the time the administrative court came to consider permission, and the question was whether a freestanding claim for damages should carry on in the admin court at the permission stage. It was relied on by the parole board in an attempt to persuade the judge below not to deal with the case on its merits. The judge rejected that. There's no appeal against that. But it does go to ground 7 and 8, and in very brief terms, I'm sorry I've trespassed into my friend's time. Hopefully tomorrow we'll allow that to rectify itself. On the Davies point, you have the references to the Summers case, that's included in the bundle. I don't think it's particularly controversial. You've seen Davies. It's the Davies earlier exceptions for acting unreasonably and failing to concede liability. What's important to note on this point, and I appreciate the learned judge didn't find in favour, but why I say he was with respect wrong on this, firstly, is that it's a clear case, as the judge found, that there was no legal defence advanced. So at no stage was there said to be a lawful excuse for why there hadn't been a hearing. No conceivable defence was advanced, or could have been. Indeed, the refusal of priority decision, which isn't relevant, was also self-evidently unreasonably unlawful because it had not applied the correct legal test at all. his lordship said in the relevant paragraphs you've seen, I think paragraph 15, 1 and 2, it's also paragraph 3, 5 on the resources point, and paragraph 9 on the refusal decision. So there was never any defence that was advanced recognised by law, and allied to that established law, there were offers to settle which were made, including those which the learned judge doesn't refer to. The first offer, in fact, was the 30th of October 2023, and this came on for trial in February 2025. In October 2023, in supplemental bundle, and I don't mean the one that the court has received today, but the supplemental bundle that the court had previously, the offer of settlement to which I refer is page 24 to 26. So as soon as the release had been directed by the parole board, on the 30th of October, page 24, an email was sent to the parole board notifying them that his release had been directed, proposing to deal with the matter by way of the attached consent order. And the consent order at page 25 to 26 didn't specify, if one looks at paragraph 2, didn't specify the damages sum. And it asked, the two important points is it asked for the reasonable costs as well, paragraph 5. Now, whilst the period of delay the declaration was sought for is larger than that which the learned judge eventually found, in some respects it doesn't go as late, it does start earlier, perhaps not very much different. But in any event, that was a different period. But what's important is there's never any concession, as the parole board repeatedly says in its letters declining any consent to settle matters. There is never any concession of any unlawfulness of any period or any type by the parole board. Page 27, paragraph 4. Over the page 28. Defendants have not admitted liability for the delays. Accordingly, in these circumstances, no reason to agree to the declaratory relief sought or to pay damages. So that's the offer of the 30th of October refused. There's an offer of the 9th of January, pages 40 to 41. That's refused. The parole board said it was premature to consider, page 53. This is in 2024. Premature to consider the Part 36 offer.
I'm sorry, where are we now?
Page 53, my lord.
Thank you.
30th of January 2024. And there were further offers in February 2024, page 63 and 64, for example. Reference to being unreasonable, being liable for costs. The next offer, again, not taken up. The next offer, 14th of June. Again, the draft order would have allowed quantum to be assessed. That's at page 69 and 71, 72. Essentially making the offer again. The parole board's response, again, page 73, been no conclusive finding or concession the delay was unlawful. And then threatening costs against the claimant, consequences. There may be cost consequences flowing from the fact there's been no public law issue since 7th of November, 7 months ago. So just refusing to deal with the matter in the ongoing proceedings that existed. The same applies in August 2024, when the offer to settle was made in the sum of a little over £15,000. Whilst the judge qualitatively found in favour of liability, he didn't quite adopt the sum of damages or the period of quantum, the period quite as high as some of the offers that had mentioned £15,000, as we know, but that had no cost bearing and nor was the option taken up to take on the assessment of damages separately after a concession of liability. There was no concession of liability, and so the proceedings incurred their costs to do so.
But were any of the offers, I think I'm right in saying, from what I've just been glancing as we've been going through, all of the offers you've just taken us to involved a consent order in which the unlawful delay was drafted as being from April 22 to August 23.
I have to say I haven't focused on those. I haven't. If my lord has seen that on a glance through, I suspect that's entirely right.
Yeah, I'm looking at page 77, for example, which I think was the last one you showed us just now. At page 77, it's the period is April 22 to August 23.
Yes. Yes. So I think the total there was 15 months the claimant was claiming. Judge said 10 months. Not actually not actually part of the same one. He went later on, started, shifted out. But my point about that is not necessarily that it was a Part 36 exact offers had been made, but that only one party tried to settle repeatedly, and that party trying to settle had also said we can deal with the amount of damages later if that's appropriate. And the Parole Board simply said no, we don't accept any unlawfulness.
Yeah, sorry, forgive me. I know time is passing. You said Part 36 a couple of times. Was there in fact a Part 36 offer, properly so called?
Well, I don't recall seeing one. My recollection is these were offers accompanied by consent orders. I know there is reference to it as that, but I don't recall that.
Okay, thank you.
They're all introduced as Part 36. If you look at the covering letter, it all describes how it's Part 36.
I'm grateful. So it was described as being such on page 64.
Covering letter for each
The
one
covering,
describes them as being a Part 36.
Okay, I'm grateful. So each covering email or letter would have said it's a Part 36 offer, essentially.
Right.
It's certainly not in the format of the template, but in any event, I can't go as far as to say we made the exact offer that the judge gave. I rely more on the fact that one party was making offers and trying to settle. The Parole Board's response, we submit, was unreasonable, having had no legal defence, but choosing not to concede any of the offers made. On the question of ground 8 and the neutrality point, the Parole Board did actively object to a rolled up hearing and raised venue, supplemental bundle 47. It made the points about costs if it didn't agree to transfer, page 62 and 63 of the supplemental bundle. And as you've seen from its processes, the first thing it decides to do is whether to concede. And then not having done so, it provided a skeleton argument for the hearing that raised venue and suggested a similar claim in Mr. Roach's case. Mr. Roach's case was very dissimilar, I've already mentioned. It was pre-permission and there'd been a concession of liability, so the only question was the damages sum. And the delay had already ended. So that's very different, not similar at all. That's what was said at page 59 of the core bundle, which alleged to be similar. But notwithstanding that attempt, the judge obviously rejected that, and that isn't unchallenged. So those points. The last case I should deal with is just to say that the special tribunal case that's cited about neutrality, in that case, the Privy Council expected the bank who made the constables redundant to have defended the decision and to be liable for the cost. Paragraph 60, page 1165, and that goes with the principle that someone ought to be able to pay the cost so that the successful litigant isn't left with them. I'm sorry that was somewhat of a speedy end, but I hope I've covered what was most helpful.
Thank you very much, Mr. Rule. Yes, Mr. Cohen.
My lords, my lady, I'm going to be addressing grounds 1 to 6, and then my learned Julius Jackson is going to be addressing grounds 7 and 8. Before I get into the meat of my submissions, I'm going to make a number of miscellaneous points which arose out of the exchanges between the bench and my learned friend over the course of today. The first point is an impressionistic point, which is simply to say that had this matter featured a privately paying applicant who had the benefit of a costs order, in all likelihood, the damages award of £10,000 would have been absorbed in costs. And just to put the flesh on that, the inter partes costs of the appellant, we still haven't been told what they are, but it's certainly in my experience tends to be a factor of 3 greater than the legally aided parties, legally aided only costs. So we'd looking at about 50 to 60,000 pounds. Your privately paying party would have incurred 50 to 60,000, had the benefit of a costs order. Now the amount that the board would have been ordered to pay would be very much less than the 50-60, not least because of the proportionality test, which post 2012 is with the benefit of hindsight and includes identifying the sums at issue in the proceedings, the value of non-monetary relief, complexity, etc., etc. So in all likelihood, the board would have been ordered to pay something like 20 to 30. Now that privately paying litigant is then liable for the entirety of the shortfall between the 20 and 30 and the totality of the costs the solicitors have incurred. And that would be far in excess of whatever the damages recovered are. I think that is made particularly pertinent in the context of this case, which was not by any measure particularly complex one. It lasted a day, there was no witness evidence, the board was neutral, it was agreed that £1,000 a month was broadly what the case law provided by way of damages for every period of unlawful detention. Now, all of that begs the question of what does a privately paid litigant do in the context of an action for a small amount of money? And the answer is they make offers. They make callback offers, they make Part 36 offers, and they use that mechanism to ensure that the post-2013 proportionality test does not see the costs award made against the paying party eroded to such an extent that any relief obtained is absorbed into the costs they have to pay their own solicitor. And that's the first point, which I accept is an impressionistic point, but much of my submissions in the context of Article 6 are going to be drawing a comparison between the benefits that the applicant has by way of legal aid as against the position that a privately paying party would be in, even in the presence of a cost order. The next point to make is that the appellant, by reason of the statutory charge being a function of legal aid costs only, is already, on those same facts, £20,000 to £30,000 ahead of the privately paying party. The privately paying party, to have this matter conducted, would have incurred £50,000 to £60,000. However, the extent of the charge is limited to the legal aid only costs, which are about £17,000. And I will take, over the course of my submissions, the court just very briefly to a schedule that sets out what some of these legal aid rates are, and they are astonishingly miserly, £60 an hour. So already the appellant, because they are legally aided, finds themselves in a privileged position in that the charge is not only operative only where damages are recovered. This isn't your classic no win, no fee CFA where you've got to pay based on result. This is a charge that bites only on sums paid. It's not even sums ordered to be paid. They must have been realised. The next is that the extent of the charge is limited to the legal aid only costs, not inter partes rates. And even that is without factoring in the other concomitant benefits of legal aid, like Section 26, cost protection. So the reality of this is that in no circumstances would the appellant have been liable to pay the board's costs. And in fact, the appellant is measurably ahead of your private paying litigant, even when that litigant has the benefit of a cost order against the board. I simply make that by way of initial impressionistic points. The next point is a point of correction. In the exchanges with my Lord Justice Peter Jackson this morning, I think my learned friend suggested that where you have a legally aided party who benefits from a costs order, that order is at the inter partes rates, which is a function of Section 21 of the Civil Aid Financial Regulations, which again I'll come to. if again we were to mirror the sums that were exchanged this morning, if the inter partes cost schedule came to £40,000 and the board was only ordered to pay £30,000, the client is not liable for that £10,000 shortfall. Where you have legal aid, in no circumstances can the client pay the service provider. That's section 23 of LASPO, which I will come to. And that's why one of the critical reasons why in the case of Faulkner and the other cases that I'm going to come to, Turkey is another example, the human rights challenge is always made to the statutory charge. It is not made to the costs order, because in no circumstances is the client, by reason of statute, liable to pay the solicitor's fees. It is
You can't have a situation where the solicitor has the benefit of a legal aid certificate, or the client has the benefit of a legal aid certificate, and they have a solicitor. The solicitor is also charging a second fee in order to make the whole thing commercially possible. That's the
my
concept.
lord, the answer is no, emphatically no. It's called unlawful topping up, and it's section 23 that prohibits it. So in civil legal aid, if you lose, the solicitor and counsel only recover at legal aid rates, and if you win, the solicitor and counsel recover at inter partes rates. But insofar as their schedule, which is obviously comprised of notional figures, because there's no retainer, there's no debt due, and what it is that solicitor and counsel tend to do is they import into the cost schedule the guideline hourly rates, or thereabouts, as being a rough indicia of what it is that they would charge were they acting on privately paid rates. And where there is a reduction, that reduction, again, because it's a set of notional figures, doesn't sound at all. All that happens is, by reason of section 21, which I'll come to, regulation 21 of the 2013 regulations, the increase above the legal aid rates to those that the other side actually pay are retained by the legal representatives. So if we were to take a different set of facts and imagine that this was simply about a quashing order and there was no damages, and this matter was then appealed, the only beneficiaries would be the lawyers, because the client, where there is no damages, property recovered, has no interest in it whatsoever. And again, that is, I think, important context here. The question as to whether a non-listing is not a judicial act, I'm going to address tomorrow, but I will flag that at the outset because there is authority which my learned junior has dug up, but I'd like to digest before I deal with that tomorrow. And the final introductory point before I come on to the meat of what it is I intend to get across in the next 45 minutes is that Faulkner is exactly on point. The costs orders in Faulkner do not matter at all. It does not matter if there's no order for costs or if there are costs ordered against you. If a cost ordered against you, as here, as was there in Faulkner, the legally aided party doesn't pay anything. Section 26 of LASPO means they only pay that which is reasonable, and the reality is, if you have civil legal aid, and I'll come to some of the regulations, but to qualify for civil legal aid, your disposable income has got to be less than roughly £600–700 on a monthly basis. The counterpoint of that is section 26, which means that you, the legal aided party, are only liable to the extent that it is reasonable given your financial circumstances. It means that costs orders made against legal aided parties are almost invariably unsatisfied. And that feeds into the equality of arms, where you are representing a party, or rather where a party is acting against someone who has the benefit of legal aid. So the fact that there were costs ordered against the legal aided party in Faulkner in the Supreme Court, Faulkner was the beneficiary of a costs award, certainly at the Court of Appeal. The fact that there were costs ordered matters not at all. The reality is, where there are damages recovered, and those damages are less than the amount that the legal aid agency has paid for the representation to that legally aided party, there is a statutory charge, full stop. And it's plain to see why in that case it would have arisen, because you had a sum of £6,500 and you had a matter that went all the way up to the Supreme Court. So in those circumstances, where you don't have inter partes costs award, and there wasn't for the two higher levels, it is hardly surprising that one ended up in a situation where the damages ordered were less than the totality of the legal aid costs incurred, taking into account any costs order made in favour of the legally aided party. and that's why Falconer is all about the statutory charge. And that's why in 3 separate cases I'm going to take you to, invariably the human rights arguments are deployed in the context of the statutory charge, because it's not the costs order that infringes any Article 6 rights. It is the statutory charge that does so insofar as there is an argument. And it is also relevant in a case that I'll come to, which is the case of Turkey, that the statutory charge is exempt, will not apply where it infringes a party's convention rights. So the overarching submission here is that the appellant has jumped the gun. The proper point and the proper parties between whom an argument about an infringement of Article 6 is to be had is between the appellant and the legal aid agency as to whether Regulation 5.1d of the statutory charge regulations exempts the statutory charge from biting on the damages. It is simply not between these two parties. My lords, my lady, one thing that I think it is very important to have in mind is the lens through which this challenge is to be understood. The way it was described by my learned friend in his answers to the bench was that in respect of the rule in Davies, what was sought was an amplification with reference to Article 6, or it was to be distinguished because this was an Article 5 case. That's the way it's been put. This is, in my respectful submission, the test that needs to be engaged with here. The appellant needs to show that in his particular circumstances, the effect of the order was to infringe his right of access to the court under Article 6, and that infringement does not pursue a legitimate aim, or there was not a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. And I will come to various cases to make that point good. This is not being put as an ab ante challenge to the rule in Davies per se. As I'm going to go on to explain, Article 6 is about individual rights. And there's a good reason for why it's not being put as a challenge to Davies per se. And that's because under paragraph 47 of Davies, there are two very important pressure release valves. The first pressure release valve, if I can put it in those terms, is in 47.1. And what 47.1 refers to, this is Authorities Bundle 286. 47.1 at 286 is where the tribunal declines or neglects to sign a consent order disposing of the proceedings. So your first pressure release valve to the rule is at 47.1. And that's where the tribunal acts unreasonably and not compromising the matter. 47.1. The next pressure release valve is 47.4. And 47.4...
Just following you through.
Yes, sorry.
It's not limited under 47.1 to not signing a consent order. It's that's just an instance. It's an example of a flagrant instance of improper behaviour.
Or when they do so. So you've got the behavioural aspect and you've got what is an
No, it's not an
unreasonable
instance. It's another. It's an alternative.
It's an alternative. So that's your first pressure release valve, and that's why a well-advised litigant in the position of the appellant should be making offers and can put themselves in a position at the end of the matter to say it was unreasonable then to refuse this offer. It's much easier to say it's unreasonable then to refuse it in circumstances where you offered less than that which you were awarded. So there's your first pressure release valve. Your next...
Sorry, I know you're trying to...
Sorry, forgive me.
I'm anxious to follow the argument. But this is considering the court's position / board's position and that would be where between you you'd agreed something and you put in a consent order, which had then not got made. Isn't that what's being described here?
That's not my understanding, model, and I will come to authority that
I may be
that
on an island of my own here, but
it is referenced at paragraph 27 at 280, I think, is the context to that.
but what it says is where the court unreasonably declined or neglected to sign a consent order, which is just a, would be a very odd state of affairs unless there was some particular reason for it.
I agree, my lord. If I can just direct you to paragraph 27, which is the originating paragraph of that statement. There is subsequent authority which I think contextualise it, and perhaps in a way that's a little bit more accessible.
Yes, your point is what's meant is declining unreasonably to sign a draft consent order.
Which might obviate the cost of an unnecessary hearing.
Yes, I'm sorry. Okay, I've caught up.
Great. The next is paragraph 47.4, which you see at 287. And the reason, my lords, my lady, why it's not put as a challenge to the rule and practice in Davies per se, in other words, divorced from the appellant's specific circumstances, is because to sustain that challenge, what needs to be shown is that the rule / practice in Davies is incompatible with the convention, whatever the facts may be. So that's why it's not being put in those terms. Just to make that point good, that's behind tab 50, the authority of re-abortion surfaces, and at page 1041, at paragraph 14, is what one has to do if one is taking issue with, it's 1041. What one has to do if one is taking issue with a piece of legislation, rule or practice, as being in and of itself not convention compliant. Paragraph 14 of 1041.
That's a challenge to a legislative provision, it seems.
Indeed. But there's a reason why my learned friend, when he went through his 7 factors as to why it is that we are in Article 6 territory, expressly made reference to the appellant's means. And that's because if you are making a challenge under Article 6, the challenge itself, and to go back to the original formulation that I put before the court, is only going to be successful if the individual litigant can show in his particular circumstances the effect of the order was to infringe his right of access to court under Article 6, and that infringement doesn't pursue a legitimate aim, or there is not a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. And my submissions are going to follow those sequential steps. I'm going to address what the appellant's particular circumstances are, and for the purposes of costs order, the fact that one party is legally aided is not to be taken into account. That's section 30 LASPO. But for the purposes of Article 6, we look at the specific circumstances of the appellant, and that's where all the concomitant benefits that come with legally aided are introduced into the discussion. So the first section of my submissions will deal with the particular circumstances. The next will address whether there is an infringement per se. I will then go on to discuss the legitimate aim. And then finally, I will address proportionality. What I will say in respect of the European cases that this court has been taken to is each one of those, some better than others, go through those sequential steps, and each one is to properly be understood in the context of the state's national legislation which has given rise to the challenge. They are simply illustrations of this sequential test being applied. And I'll come to some of them relatively briefly and time permitting. dealing with the logically prior question, which is what is the basis for this sequential analysis? Well, we see it from Imperium Trustees, which is behind tab 55 of the authorities bundle at page 1190.
Realised that my printout of this case is completely mad. A series of little boxes rather than printed. There's a tiny bit of printed text, but most of it is quite bad. Quite hard to see the distance below.
My dear, what I might do then is make the submissions, and then perhaps
Yes.
I can summarise them again tomorrow morning.
Yeah, that would be really helpful.
I don't in a sense want you to be coming at this.
Yeah, sorry, I've only just realised that.
I wonder if
Mine's all right.
Isn't that weird?
Isn't that weird?
Yeah. Got a little gremlin in the printer.
Have some old-fashioned.
Oh, thank you very much. It's all right, I've now got
I think it's all right.
a legible copy. Thank you.
quicker. The question before the board in this case concerned a disclosure notice and Article 6, and a subsidiary question, which is whether a statutory provision which insulated the Jersey Competent Authority from an award of costs breached Imperium's Article 6 rights. The context appears, and I'm going to move through these paragraphs relatively quickly. Paragraph 8 on 1195 is the notice. This was a disclosure notice at the behest of the Belgian authorities in respect of a company, or the Imperium trustees, I should say, which the Jersey Competent Authority issued. That's paragraph 8. Paragraph 11, Imperium then applied for leave to apply for judicial review of the decision to issue the notice. That was then heard by the Court of Appeal of Jersey, that's paragraph 16, and they allowed the appeal. Over the page at 1197, paragraph 19, we then come to the issue of costs. Imperium then sought an order for costs, having successfully JR'd the decision to issue the notice. 20. The Jersey Competent Authority resisted the making the order for costs because of Article 2.1c. These purposes you just need to notice Article 2.1c because I will come on to explain that in a minute. At 24 and 25, the Court of Appeal concluded that that article was not compatible with Article 6.1 and made a declaration of incompatibility. The issues are set out at paragraph 28. The first issue was whether, in fact, Article 6 was engaged in relation to the notice of disclosure. And the answer to that was no, it wasn't, because it fell within the tax exemption. But the subsidiary question is 28.2. Whether in such proceedings the operation of Article 2.1c of the 2018 law is incompatible with Article 6.1, and the text of that particular article appears at paragraph 37. It's 1202 at F. And what one sees at paragraph 37 is Article 2.1c says the public authority shall not be liable for costs in respect of the act done in pursuant to its functions. The discussion as to whether Article 6 was engaged in the substantive matter, which was the issuance of the disclosure notice, goes from paragraph 40. And then at paragraph 70, the board concluded that the JR proceedings did not involve the termination of civil rights and Article 6.1 was not engaged. It then went on from paragraph 70, this is 1213, to make various observations in respect of the Article 6 challenge in relation to the costs challenge. And if I could just ask you to read paragraph 74.
So these are orbital observations.
All over. Yes, my dear. Paragraph 74, the final 2 sentences. Imperium relied on 2 aspects of Article 6.1, maintaining that the costs rule was a restriction on the right of access to the court and infringement of the public principle. Infringement of the principle of equality of arms. In the case of each, it was necessary for the Court of Appeal to consider whether the cost rule was an infringement of Imperial's convention right, and if so, whether the cost rule legitimate aim, whether it was proportionate. So that's the sequential steps which I'm urging upon the Court. And then at 77, if I could just ask Court to read 77, 78. And then 80. And at page 80 in the middle of the page, the case, which is a slightly unpronounceable case, Jacob Vicius is the best I'm going to offer, but I'll call it Lithuania for the sake of my dignity. It is set out at C, which I'm going to come to. Under E, you'll see that in that case, the court undertook what was described as an intensely fact-sensitive approach to deciding the proportionality of the infringing measure. And that's what is required. At G is the comment that in this case, the Court of Appeal had no direct evidence on the effect of the breach. And it's for that reason that the appellants, with the witness statement and the second supplementary bundle of yesterday, is put in a sense to try and ameliorate that criticism, because what is required is an intensely fact-sensitive approach, because it's the appellant's Article 6 rights that are breached. And that's why we now have, for example, information as to his bank statements and income and the like. And then 83, again, is just the reminder that one deals with this in the context of the individual that's making the argument, rather than simply taking it as an abstract challenge in and of itself. Legitimate aim is then addressed at 84. And when we're looking at legitimate aim, it's the final 6 lines of 88 that is going to set out what it is that this court needs to do when it looks at the legitimate aim of the rule of practice in Davies. And again, in my submission, that's fundamentally the wrong question. But if it were the right question, then the final 6 lines of 88 sets out the question that this court need to address. In other words, it's why is the rule and practice what it is? Well, Elisabeth, I'm going to go to 2 European authorities, again, relatively quickly before I take a step back and then summarise my overarching submission on the remainder of the European authorities which you've been taken to. The first is going to be the Lithuania case, which is mentioned by the board in its decision. And that appears behind tab 51 at page 1081. Paragraphs 4 and 5 at 1081 is the context. This was an individual who took a breathalyzer test, and it came out that he was over the limit. But the reason why he was over the limit was because he had used a spray in his mouth which had a very high alcohol content. And that's paragraph 4 and 5, and then paragraph 11 the results of the breathalyzer test were not considered reliable, because he then subsequently took a blood test that actually showed that he didn't have the level of alcohol that the breathalyzer test suggested, and his explanation for that was that he had used this mouth spray. What then took place is, having gone through the process of exonerating himself, at paragraph 13, he then sought his costs. That's the second sentence of 14. He wanted costs of just over €1,500, which for the DNA blood test analysis and then the lawyer's fees that he'd incurred in exonerating himself. And that was dismissed on the basis that the original set of decisions were not unlawful in and of themselves. At paragraph 54 on 1092, is the discussion so far as Article 6 is concerned, and as is always the case with these decisions, it starts with the admissibility, which one sees at 1093. Having concluded that it's admissible, the court then does set out the parties' submissions, which is 1095, and then having done so, the court deals sequentially with the discussion, and that starts from paragraph 71 at 1097. And if I could just invite the court to read paragraph 73 and 75. Under 75, we've got the application of the above principles to the present case. At 78 is the conclusion that the fact that he had to bear the costs of his legal defence did amount to a restriction. So in his circumstances, there was a restriction, and then over the page at 1099, we have the questions that then follow from that. Was there a legitimate aim? The legitimate aim there was simply that it would cost the state quite a lot of money to pay. We see that at paragraph 79. And as I will go on to show, the legitimate aim hurdle is relatively low. And then we have the discussion as to whether it's proportionate to the aim pursued. And in the context of the discussion from paragraph 80, one of the things that one sees at paragraph, in the final 4 lines of paragraph 82 and 83, are the specific contentions that the applicant put forward or did not put forward. To the bottom 4 lines of 82, the applicant did not contend that in order to effectively defend himself, he needed the services of a lawyer. At 83, he did not contend that payment of the costs that he had to incur had a disproportionate burden on him in light of his financial situation. At the top of page 1100, the court makes the point that he was not in a worse position than he had been before litigating. And one of the fundamental features of the statutory charge is that no legally aided party will ever be in a worse position than they would be before they started, because it bites only on damages recovered. And at 85, the court concluded having gone through that proportionality exercise, there was no breach. The next case I'm going to take to you before I step back away from the European authorities is the Croatia case behind tab 54. The facts are set out from paragraph 2 to 17, but in brief, this was a case where there was a decision that the child should live with the mother. The child then went to live with the father, and there were 3 years' worth of litigation while the mother tries to get the child delivered back to her, only for the child to then turn 18 and to be able to make the election. And that's the enforcement proceedings that one sees from paragraph 7 to 17. And what she sought were the costs of the various court proceedings that she then had to go through. And we see that from the final 3 lines of 22, which has got a reference to €165, the same sum again for the appeal of 24. And then at 26 is the sum of €812. And those sums were evaluated by the court in light of the compensation that she'd been awarded for the delay, which was €663. That's paragraph 27. And if one goes to paragraph 53 on 1178, the court sets out the matters before it, which was the inability to recover the costs of legal representations. That's 53 on 1178. Substantive discussion starts at paragraph 79. This is 1183. And again at 79 we have that overarching set of questions. Is there a restriction? If there is a restriction, it will not be compatible with Article 6 if it doesn't pursue a legitimate aim, and if there's not a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. And then at 82 and 83, or 82 particularly, there are 2 categories of cases that are set out at 82. In the first category of cases, are cases where the applicant is financially worse off for having litigated. So that's class 1, which I'll come to, and I'll come very briefly to touch on those decisions that are in class 1. But class 1 is where you are in a worse position for having litigated. But again, that self-evidently doesn't apply in the context of the statutory charge because you can never be in a worse position. The category 2 cases are ones where, notwithstanding that the applicant has won, they have still had to pay their opponent's costs. And both of those cases focus on a particular cost provision within the Croatian costs rules that my learned friend alluded to, whereby your costs are a function of what % you recovered against that which you claimed, and to the extent that you've got a small % of that which you claimed, you end up having to pay the other side's costs. So if you get 75% of that which you've claimed, the other party pays 75% of your costs and you pay 25% of their costs. And on these particular facts, they were very high levels sought, and it meant that actually the party who won ended up paying the other side's costs to a greater extent to the degree they were wrong. That's class 2. And what I will emphasise for each one of these cases is that they are incredibly fact-specific. They all are a function of the domestic legislation that's under the microscope, and each one follows that same set of sequential questions. In the applicant's circumstances, has there been an infringement of the Article 6 rights? If yes, is there a legitimate aim? And proportionality between the end and the aim. In paragraph 85, we see one thing that concerned the court was that the costs of getting, in other words, the compensation was less than the cost that she had incurred. The compensation was about €660, and she'd incurred comfortably more than that. You see that in the middle of 85. Over the page at 86, the government adduced no reasons or explanations for that. This was in the proportionality assessment. 86 and 87. 88, the government failed to put forward any sufficiently convincing reasons to justify the situation. And then at 93 is the conclusion. At 98, the court notes the applicant claimed just over £2,000, which corresponded to the total costs. And at the final line of 100, they awarded the applicant just over £1,000. As with many of the decisions, the reasoning for that reduction, a certain amount to be desired. But again, it's noticeable the way that the appellant puts this case is it is as if the statutory charge, which is a loan where you win, should be treated as a grant, as if the appellant had lost. But that's not even supported by the case law, which, as this case shows, provided a 50% haircut in any event. My Lords, as you will recall, paragraph 82 and 83 had these 5 cases which loom large in the appellant's submissions. I'm going to spend no more than 15 minutes, if I may, just moving through them very quickly, simply to support the core propositions that I put to you in respect to those cases. And by way of a reminder, those propositions are simply that each one concerns distinct statutory regimes, each one focuses on the impacts of litigants, and each one follows the same structure which I'm commending to this court, which is to focus on the applicant's circumstances, whether there is a restriction, legitimate aim, and proportionality. Part of the reason why I'm going to take the next 15 minutes is certainly the focus of my submission, which I'll deal with tomorrow morning, is more important, allied to the fact that because I'm simply trying to group them into certain categories, I needn't go into the merits today in great detail. The first one mentioned in paragraph 82 of the decision I've taken you to is behind tab 48. The context of this particular case was this was an individual who was deprived of legal capacity.
Go ahead, Mr. Cohen.
This is 986. This was an individual who was deprived of capacity and then had to go to court to prove that he did have capacity. His complaint at paragraph 11 is that it cost him just over €6,000 to get there. He didn't get his costs, even though he had proved that he had got capacity. It's paragraph 15, has section 23, which is that each participant constitutional court proceeding shall bear their own costs unless the constitutional court decides otherwise. On that case, they did not. and it's paragraph 23 is the complaint. That's 990. Paragraph 48. The costs of going to the Constitutional Court were more than the average salary in Croatia at the time. That's paragraph 48, 994. So whilst he had obtained relief, it cost him money to do so. And then the discussion starts from paragraph 68 onwards. And 69 is the reiteration of that sequential test. The court needs to ascertain in present cases whether the effects application of the rule are compatible with Article 6, and then it goes on in paragraph 70 to make the point about an imposition of considerable financial burden. The legitimate aim proportionality is then addressed at paragraph 74. Legitimate aim is shown at paragraph 77. That particular rule was held to have a legitimate aim because the focus was to secure the court's smooth functioning and to protect the state budget. That's 77, and again, that just feeds into that legitimate aim. So where should we go? Proportionality is then addressed from 80 onward, and what loomed large was the fact that the costs that were incurred going to the Constitutional Court were greater than the monthly salary. The next case is behind tab 47, and again, what's important about this case and the other two that are within this category is that the costs are greater than the relief obtained. In this case, there was no relief other than a declaration of capacity, so there was no monetary award that was going, and yet it cost him €6,000 to get the declaration of compatibility. And that's what troubled the court. At tab 47 is another case, again against Croatia, which seems to be the source of much of this law, for better or worse. Paragraph 5960 is the summary. This case, as we can see from paragraph 5, was all about entitlement to disability benefit. Paragraph 5 is the context. Paragraph 24 is the fact that the final redress was that she was entitled to it. And again, this was an action against the Croatian pension fund. The costs rule in question is paragraph 41, which is 965. And what took place is originally the cost rule in question was section 79.3 on 965. That was originally as it was, which is just a general discretion toward costs. At the time at which this applicant's hearings below took place, that rule had been superseded for the rule that you see at the top of 966. There was, at the stage of the point at which her matter was determined, a rule that said each party bears its own cost, full stop. No discretion allowed. And then the Constitutional Court of Croatia in 44 struck that rule down and replaced it with the previous rule. But the applicant was, in a sense, stuck in this no-go zone where, notwithstanding the previous edition and the later edition, her costs award was made under the intermediate edition. 114 is the fact that it had cost her roughly €4,000 to get where she did. And then if we come back to the substantive discussion, we see that at 97 to 99. And at 97 to 99 is the fact that a considerable financial burden after the conclusion of proceedings may constitute a restriction. So that's 98, that's the first step. Is there a restriction? That's 98. The principles then applied at 102. 104, the court simply takes the absence of a legitimate aim from the fact that the Constitutional Court had already deemed that provision as not having a legitimate aim. So there's a danger in drawing too many conclusions from this case, because actually all the European Court did was say, well, the Croatian Court had already struck it down as not having a legitimate aim, so we are simply feeding that in to provide the redress. And we can see that at 106. And again, what's important about this case is we've got someone who having to bear their own costs, which means that notwithstanding she now has her pension, she is in a worse position because it has cost her money to do so. And again, with the statutory charge, you are never in a worse position. The final authority in this category is behind tab 45. And again, this is the category of worse position for having litigated. Paragraph 7911, a fine of €500 was imposed because a particular company hadn't displayed a certain notice. Paragraph 10, this is 911, it cost them €1,169 to have that fine overturned. No costs were awarded because the court concluded that the original imposition of the fine was not unlawful in and of itself. Paragraph 66 on 928 is, again, the formulation of the test that this court will need to grapple with at 66. Second sentence, contracting state enjoy a certain margin of appreciation, although final decision is the observance of the convention requirements of the court. Satisfied that limitations applied do not restrict or reduce access in the way that the very essence of the rights impaired, which obviously doesn't apply when we're dealing with costs, because one has come to court anyway. This is costs after the event. Furthermore, a limitation will not be compatible if it does produce a legitimate aim and there's not a reasonable relationship. 67, it's not this court's role, or rather the European Court role, to express a view on the limitations. And then at the bottom of 68, final three lines of 68, refers to a worse position than they were before litigating. And the top of 929 makes the point the financial burden on the applicants was nearly double or treble that they had initially faced. They were faced with a €500 fine, and it cost them over €1,000 to have that wiped out. '69, there was nevertheless still a legitimate aim. 69, the legitimate aim hurdle is low. And then at 73 is the conclusion that there was a disproportion, which was a function of the juxtaposition between the original fine and how much it cost to get it removed. Now that, my lords, my lady, is the first category of cases, and that's all about being in a worse position for having litigated. The second category of cases, which I'll touch on for 5 minutes only, just so I can move past this point, so to speak, is where individual had one that was ordered to pay the costs of the other side. In both of these cases, again, this is about Croatia, but both of these cases involve this peculiar Croatian costs rule, whereby the costs that each side are ordered to pay are simply a function of recovery as against the amount sought. The first appears behind tab 32. Page 570 to 571 is the context. This was ill treatment by a policeman. At paragraph 13, what it was that the applicant sought was 335,000 of the domestic currency. Paragraph 15 sets out that the amount that was actually awarded, this is 14 and 15, the amount that was awarded was 14,500, so a very small percent of the original that was sought, that was comfortably over 300,000. And then 15 has got this extraordinary operation of the cost rule, which is because the applicant only got 4% of the amount that was sought, the applicant got 4% of costs from the state, and the state got 96% of their costs from the applicant. That's paragraph 15. And then again, the discussion, just to make that point good by way of explanation, is paragraph 81 on 591. '81 makes the point that the rule in that case is a function of the proportion of the success in the proceedings. 82 makes the point that there's no incompatibility per se, because you can still get to court, just as the appellant has got to court here. But the question is there at 83, which is the classic formulation. And then the conclusions in this case, again, a classic formulation, 83. We then have the question of whether it pursues a legitimate aim, which we find under C. And again, at 84, bottom 4 lines, there is a legitimate aim because it discourages excessive claims. From 86 is the proportionality discussion. And then it's the bottom 3 lines of 96 and 97 is the absence of proportionality in those circumstances. Final case, final 2 minutes. Before I sit down, so to speak, is behind tab 46. Uh, 46, page 936, paragraph 5. This was an applicant who brought a civil suit because they were beaten up, physically assaulted by someone in a restaurant. Paragraph 6 and 7. Sets out the context, and then the judgment on 937 is 6 paragraphs up from the bottom. It says the total cost of the part of proceedings, it says since the applicant succeeded with 25.96% of his claim on this part, he is entitled to 25% of his costs. And then if you look at the bottom 3 lines on 937, he then has to pay 74% of the other side's costs. It's the same costs rule as the one that was in the previous case. And then this was upheld in the Supreme Court of Croatia, and then at paragraph 50, again makes the point that in the context of the amount that they had been awarded, specific context of the amount had been awarded, paragraph 50 at 950, the costs themselves and then were disproportionate, and then the discussions at paragraph 59 on 952. Elisabeth, I'm sorry for taking that a bit of a rush. It was partly because I'm just trying to draw common themes from these cases.
Mm-hmm.
But the overarching point in respect of the European law that you have been taken to is that it's distinct statutory regimes. We focus on the litigants concerned. The 2 classes of cases, one is worst off litigating, the other is successful but then has to pay the other side's costs, neither of which does this case fall within factually. And then the common thread is the test. And it'll be in my submissions tomorrow that I will focus on the test by dealing first with this specific circumstance of the appellant. I will then focus in on how the order affected the appellant's rights under Article 6, and then I'll move on to the legitimate aim of the proportionality discussion. Elisabeth, unless I can assist you further at this point, convenient.
Thank you very much, Mr. Cohen. We'll see you at 10:30.
Can I just make sure the court is aware? I'm afraid I apologise for my absence tomorrow. I think the court is aware of that in advance. I'm very grateful for the accommodation of the court. Thank you very much.
Mr. Rule, thank you.